Hello friends, a very warm welcome to Unsarkari. I am Vikas Bhardwaj. Today we are going to take up a very important and a special topic, that is India versus UK Constitution. What are the key contrasts? What are the points you must learn not only for the prelims but also for the mains and interview preparation? Very important for political science, anthropology, public administration, elements of sociology, and so forth. So, let's go ahead in a smart way. Nature of the constitution, when we see, then in case of India, we know it is a written, detailed, and a codified constitution which is longest in the world. But UK is unwritten. It has evolved from statutes, conventions, and even judicial decisions. Three key words I am giving you. Make a note of it. If we see in details, then Indian constitution is a written, detailed and a codified constitution. It is a single document adopted in 1950 and drafted by the Constituent Assembly. Lengthiest constitution, around 395 articles plus 12 schedules originally. And there are explicit provisions including fundamental rights, that is part 3rd of the Constitution, DPSP part 4 of the Constitution, that is directive principles of state policy, and federal division of powers between union, state and concurrent list. Very important. For example, right to equality is clearly codified and enforceable in courts. That's one way to understand nature of Indian constitution. But what about the UK ones? So it is unwritten, evolutionary and flexible in nature. So that means it is not a single document, unlike India. Constitution is a mix of statutes, conventions, and judicial precedents and authoritative works. For example, Magna Carta, 1215 AD, which went on to put an early limit on monarchy. Magna Carta we have discussed in context of World History series. Bill of Rights 1689, that is bringing parliamentary supremacy. And Act of Parliament, for example, Human Rights Act 1998. And there are conventions. For example, Prime Minister must be from House of Commons. We are going to see conventions in details. So, the principle of collective ministerial responsibility is a convention, not a written law. Very important to note. Let's see another element of supremacy. So, in case of India, there is constitutional supremacy, parliament bound by constitution, and judicial review ensures compliance. I hope it is very clear. But what about the UK? In UK, there is parliamentary supremacy. Parliament can make or unmake any law, and courts cannot strike down the courts. Acts. Very important to understand. So, in case of India, let's see with examples how constitutional supremacy is there, because the principle of the constitution is supreme. It is there. All laws and actions of parliaments and even the executive must conform to the constitution. So judicial review is there and Supreme Court can invalidate laws that violate constitutional provisions. There is basic structure doctrine which held that parliament cannot amend the constitution in a way that destroys its fundamental framework. So that is why judiciary went on to enforce a limit on amendment power through Keshwanand Bharti case. So Indian constitution is supreme, court can strike down the laws, basic structure doctrine is limiting the parliament. But what about the UK? In case of UK, parliamentary supremacy is there. Let's see with examples. For example, parliament is sovereign. It can act or repeal any law and is not legally bound by higher written constitution. Not legally bound. And courts interpret and apply acts of parliament, but they do not invalidate primary legislation. They are not going to, completely invalidate whatever is done by the parliament, but they may disapply subordinate legislation or issue declarations. So fundamentally, unlike India, it cannot do so. So there are tensions. For example, there is an example of case Factor Tam and Miller, which shows that court is bound to navigate through different kind of situations and resolve conflicts. For example, European Union law or prerogative powers. So ultimately, there is respect for parliamentary sovereignty in case of the UK. The Human Rights Act 1998 allows court to issue declarations of incompatibility. It can, show its dissidence, but it cannot strike down primary laws. So in UK, Parliament is supreme. Court can interpret but cannot nullify acts. Political processes must find a solution, and political processes in the Parliament are going to solve the problems. So that means what we can say in terms of legal basis in India, supremacy is there of the constitution, that is written text, whereas in UK supremacy rests on parliamentary law and convention. So who checks the power? In India it is judiciary, and in UK political checks, conventions, and courts are only acting as interpretative tools. They are not the final arbitrators. Similarly, when we talk about constitutional conventions, there are similarities. So, one is of parliamentary responsibility. Both systems follow the convention that the Council of Ministers is collective responsible to the lower house in India and the House of Commons in UK. In both the nations, there is Prime Minister's leadership. He is the real executive head, or she is the real executive head. That's what we can say, but it is not explicitly mentioned in the constitution. Cabinet confidentiality is also an important point where cabinet discussions remain secret in both the systems. It is ensuring continuity in public decisions. Very important points. So there are contrasts also. For example, in case of India, many conventions are codified into written constitution, like President acts on the advice of Council of Ministers, Article 74. But in UK, conventions remain unwritten and it is evolving through time and practice. So monarch must appoint PM from majority party is a convention in the UK. In case of India, the head of the state, for example, president is largely ceremonial and it is explicitly limited by constitutional text. Similarly, in UK, monarchs' power are curtailed by convention, but they are not codified by law, whereas in India it is the constitution which is limiting it. In UK, when we talk about judicial recognition, courts generally do not enforce conventions, they remain political practices. But in India, court may interpret conventions if they are linked to constitutional provisions. You know, so that is why the role of courts is very, very important in case of India. So what we can finally conclude that in terms of flexibility, conventions in India are more rigid due to codification. In case of UK, they are more flexible and they are adapted to political needs. For example, evolution of the office of the Prime Minister of UK. Now, when we see federal versus unitary powers, so in case of India, there is federation, but there is a unitary bias. That is division of powers between union of states. It is tilted towards union. But in UK, it is unitary in nature and powers are devolved to Scotland, Wales, Northern Ireland, but Parliament retains ultimate authority. Very important to remember. So, if we go into details, India, if we see some key points and examples, first of all, enumerated federal structure. So, constitution is dividing subjects into union, state and concurrent list, that is 7th schedule. So, it is a clear allocation of legislative competence of both state and center. Residuary powers are given to the union and it is actually giving a decisive edge to the center on the matters not listed for states. There is emergency provision which is further strengthening central control. That means there is a constitutional provision which is allowing center to assume greater control during national, state or financial emergencies. For example, Article 356. And there is an independent judiciary which is going to resolve dispute between state and the union, and it is going to interpret the division of powers and reinforcing what is actually written in the constitution. But in UK, let's see, unitary state with statutory devolution. That means the Parliament of UK has created devolved legislatures. Which are devolved legislatures? Scotland, Wales, and Northern Ireland by statute. That means these bodies exercise powers delegated by Parliament. That also means court can actually give decisions on them, but not in case of Parliament of UK. Parliament sovereignty is more important over devolution. So devolution is revocable because it is based on the acts of Parliament. For example, Scotland Act. So ultimate legal authority is remaining with the Westminster, that is the Parliament. And when we say asymmetry in political tensions, because devolution is asymmetrical, because different nations have different powers. When we speak about Scotland, Wales, Northern Ireland, they all are having different kind of setup and different kind of needs. So creating issues like West Lothian question and priority calls for further constitutional reforms that we can see if you go and further read about Scotland, even Northern Ireland, and even Wales. So there is no written federal constitution because there is no codified constitution. So the balance between central and devolved powers, it is evolving through legislation or judicial decisions or even political practice. So what we can say, what we can conclude is India federal structure with union, state and concurrent lists, center holds judiciary powers, even emergency provisions are there, and center is going to override in case of crisis. In UK, it is a unitary state, devolution created by the acts of parliament for Scotland, Wales and Northern Ireland, but the devolved powers are statutory and asymmetric, and actually ultimate power, ultimate authority is in the hands of UK only, that means Westminster. So you can quickly contrast by saying Indian case is reflected by constitutional protection for state powers, constitutional protection by even by judiciary one can say, but in UK it is the political and statutory devolution which is supreme. Now let's say citizenship. There is single citizenship for all Indians, but in UK multiple citizenship categories are there. You can say British citizen, overseas territories and so forth. Let's see fundamental rights. In India, fundamental rights are guaranteed by the constitution enforceable by courts. But in UK, the rights are protected mainly through statutes, that is Human Rights Act 1998, and it is not entrenched in the constitution which is not written. That means in India, you can say rights are codified, that is part 3 of the constitution. Rights are justiciable by Supreme Court and High Court. They can strike down the laws which are violating fundamental rights. Judicial safeguards are there. For example, there are writs, habeas corpus, mandamus, prohibition, quo warranto and certiorari. And there is an amendment constraint on the parliament through basic structure doctrine. Article 32 and 226, they are empowering courts to enforce rights directly. But in case of UK, no single written bill of rights. That means protection relies on statutes, common law, and international obligations. Human Rights Act 1998 incorporates the European Convention on Human Rights into domestic law and allows court to issue declarations of incompatibility. That means courts cannot invalidate primary legislation by the parliament, so parliament remains sovereign and can respond to any kind of declarations. So there is a flexibility. For example, rights protection can be expanded, limited or repealed by the ordinary acts of parliament. So human rights acts of UK shows that UK's courts influence on the rights protection is there, but then the acts of parliament cannot be sidelined, they cannot be nullified. So that means we can say India is having rights which are constitutional, entrenched and enforceable. Whereas in UK, the rights are statutory and political, enforced through interpretation and declaration rather than nullification. So, judiciary, when we say independent judiciary with power to judicial review is the hallmark of Indian constitution. Whereas in UK, judiciary is independent but cannot invalidate parliamentary acts as we have just discussed. That means in case of India, independent constitutional judiciary, Supreme Court and High Court having power of judicial review to ensure laws and executive actions they are conforming to the constitution. Power to invalidate legislation lies with the courts. They can strike down anything which is violating fundamental rights or other constitutional provisions. That means basic structure doctrine is going to help in that. And the parliament cannot amend the constitution the way it likes. It cannot destroy the basic structure of the constitution. That also means in the case of India, there are tools of direct remedies with the citizens because citizens can approach the courts under Article 32 and Article 226 for writs, as we have just already discussed the four kind of writs which are there in case of India. But in UK, there is independent judiciary within parliamentary sovereignty. So UK courts are independent but operate under the doctrine that parliament is sovereign and primary. So no power to invalidate acts of parliament. Courts do not strike down primary legislation. They interpret statutes and may declare incompatibility with human right obligations. But there are practical judicial checks. As I've already stated, Factor, Tame, and Miller courts have asserted limits on executive power, and they have clarified the need for parliamentary authorization for major actions. That means courts are respecting parliamentary supremacy in one way or another. They can disapply subordinate legislation and issue declaration under Human Rights Act 1998, but they cannot sideline the primary parliament acts. That means if we see the head of state and government in case of India and UK, in India, president is there, head of the state, ceremonial post, prime minister, head of the government. In case of UK, head of the state is monarch, which is symbolic in nature, and prime minister is head of the government. Now let's see speaker's powers. In case of India, Speaker of Lok Sabha, when we talk about its election and tenure, elected by Lok Sabha members soon after the House is constituted and it is holding office during the life of the Lok Sabha. That means Speaker's office is having constitutional authority because it is created by the Constitution and it is actually exercising powers given under the Constitution and rules of procedure. That means the Speaker of Lok Sabha decides admissibility of questions, motions, private members' businesses, and he is presiding or she is presiding over debates and maintain order. Whether any bill is money bill, it is going to be certified solely by the Speaker, and certification is final and not justiciable. The Speaker can suspend members for disorderly conduct, interpret House rules, and court generally do not interfere in Speaker's discretionary rulings. But in case of House of Commons, we can say the Speaker of House of Commons is also linked with election and impartiality. For example, elected by MPs, and on election of Speaker, the Speaker is going to adopt impartiality, and he is or she is going to sever active party ties, which is not the case with India. So, President. The speaker in House of Commons is going to preside over debates, enforcing standing orders, select which MPs are going to speak, manages questions of time, and also how legislative progress will be taking place. He or she is also having disciplinary powers, can call members to order, name them for suspension, apply sanctions under common rules. So you can just contrast with the Indian speaker. And the Speaker of House of Commons is not having vote except to break ties. Follows the Speaker's Denison Convention to vote in a way that allows further debate or maintains status quo. Speaker of House of Commons also chairs the House of Commons Commission and acts as Commons representative in state and international functions. So there are certain similarities and differences between the Speaker of Lok Sabha and the Speaker of House of Commons. Let's see the key contrasts. Then in case of India, Speaker is constitutional office. UK Speaker's authority is parliamentary and conventional. That is the source of authority. In case of money bill rule, Indian Speaker certifies money bills with finality, whereas in UK no equivalent statutory certification is there. Both are expected to be impartial, but the UK Speaker's formal convention of severing party ties is more pronounced. In case of India also, the Speaker is impartial. Judicial review, when we say Speaker's procedural ruling in both the houses are largely internal and non-justiciable. Though the Indian Speaker's decision on money bill have been subject to political debate because it is also non-justiciable. So these are many important ideas which I have given you for further reading so that you can understand, prepare your own notes and excel in the examination on this topic. Do share, like, and obviously you can join our courses which are both short term and long term in order to get success in the UPSC CSC examination. Thank you very much.